The net effect is that will be fewer children reassigned to schools, ostensibly because of findings by HEW, Department of Health, Education and Welfare, that there's an imbalance in their school system. The misnomer that most people have is they think most children that are being, quote, bused are being bused as a consequence of court orders, and that's just not true. There are more children on buses as a consequence of HEW's threat to withhold funds to a school district unless they bus than there are as a consequence of a court order. And and that's why I think that Senator Brooke was justifiably concerned about that amendment. If you are a proponent of busing, you should be worried about the, quote, victory out there, because it has a much broader effect than most people think it has.
Isn't it simply going to force those who are proponents of busing to go to court? And as Senator Humphrey said, you're going to end up with more court-ordered busing?
I think not, because the so-called Byrd Amendment, which was an outgrowth of the so-called Biden Amendment, stood for almost 2 years without one challenge to it. And then on May 25th, the Attorney General of the United States of America wrote an opinion saying that it didn't have any effect. But everyone thought it had the effect, and it stopped HEW from being involved in threatening to withhold funds. They didn't do that anymore for the past 2 years. And no one challenged that, not that I'm aware of. At least there was no court that ordered busing as a consequence of any challenge. So I think that is, that's a red herring. It's just not the case. At least it wasn't for the past 18 months, 2 years. I don't think it should be left to any bureaucrat in any agency, including even if it were the Justice Department, which is the legal arm of the executive branch, to make a determination that a constitutional violation exists without having to make that judgment and go through a court to get that determination.
Are you saying threats have been made by HEW where no grievance exists?
Oh, no. It depends on who says there's a grievance. HEW, there's a grievance, someone complains, or an HEW administrator goes in and says, we think there's an imbalance, or we think, HEW thinks that there's a constitutional violation. All I'm saying is, and all Senator Eagleton said was, HEW has no power to do that, and that is a power that should not be given to a bureaucratic agency. We have courts there, the district court. Any individual, any school district, any group of people can go into a federal district court and say, we believe there's a constitutional violation. Let a court decide that.
Are you and Senator Eagle saying that if a court decides that in Delaware, that in Missouri, there should be busing, that you would never oppose it again? You'd say, let's go do it?
Yes, that is correct. If they decide it under the present ruling of the Supreme Court, which says, the most recent ruling as of yesterday, which says there must be a finding of segregatory intent to discriminate.
Well, that's very difficult, though.
Oh, sure it is, but that's for the courts to decide, isn't it?
In other words,
that's the whole issue.
If the court decided and didn't find in line with yesterday's decision, you'd still oppose it?
I'd still oppose it, yes, because it is not in line with the highest court in the land's ruling. A district court would be abusing their discretion if they did not find, in my opinion, clearly now under the cases of yesterday, unless they in an opinion say, we specifically find there was a specific segregatory intent on the part of XYZ to preclude blacks or Spanish-speaking Americans or whomever from attending this school. Therefore, their constitutional rights were violated. Look, folks, we keep talking about this thing as being North versus South. That's not the issue. It is rural versus urban. And most of the busing that's taken place to date has taken place in rural areas, whether it's be administratively ordered or court ordered. Now we're moving into applying the same standards to urban areas. And it is a standard that doesn't make sense. It doesn't apply. It doesn't hold. We're moving from trying to, in urban areas, we've had integrated facilities but segregated neighborhoods. And in rural areas, we've traditionally had integrated neighborhoods but segregated facilities. And they've applied the same standard and the same test. So this north-south thing is not really the issue. As Professor Nathan Glaser at Harvard has indicated, as Dr. Armour of the RAND Corporation, as James Coleman, as I just held 3 days of hearing, two days of hearings in the Judiciary Committee on another bill I have, beyond this that deals with busing. And there is uniform opinion of those who testified that it is not a north-south, it's an urban-rural question, a distinction.
But no matter what your intent, there are going to be those who say it's a segregated thing, it's a question of race, and that you have set back the movement of desegregation of schools. How would you answer that?
The way I answer that is I predict that the young black leadership of America will overwhelmingly decide with me. I predict that in 1980 and 84, my position will be totally vindicated by the sociologists and by the civil rights advocates. You know, I come from that side of the track. That's where I'm from. I was a defense lawyer. I handle civil rights cases. I sat in on Route 40. I mean, I'm not from the other side of this. And I happen to think that the one way to ensure that you set the civil rights movement in America further back is to continue to push busing, because it's a bankrupt policy. And that's why I think I'll be vindicated. I don't include myself with pro or anti-busing forces. I think the only group that can determine whether or not a constitutional violation exists is the federal courts of the United States of America. No one else has that right. Secondly, a federal court of the United States of America in determining a violation of the Constitution with regard to school desegregation cases must find that there is a specific intent to segregate before they can order busing. That I abide by, that I legislate by, that I hold by. And they're the standards we should repair to. It's difficult to establish intent, but it's clearly possible. Factually, it can be established. The Supreme Court 8-0 ruled yesterday that they must find that. And you very well know, as covering this area as long as you have, that there are legal standards by which you bring in burdens of proof to establish whether or not there was a specific intent.